You're listening to the Valley Current.
On January 30th, 2024, a Delaware judge wiped out $55.8 billion with, well, a single stroke of her pen.
Yeah, just completely wiped out.
Right. I mean, it was the largest executive pay package in the history of public markets, and it was just totally nullified. And within hours of that ruling, Elon Musk took to X and essentially, declared war on the most powerful corporate court in America.
You really did. He told the whole world to never incorporate your company in the state of Delaware.
Which is wild. And that single tweet or that moment really triggered what financial insiders are now calling Dexit.
Right, the Delaware exit.
Exactly. This massive corporate exodus away from Delaware, which has been like the undisputed king of American business for over a century, toward a brand new alternative in Texas.
And it is a fascinating shift. We are looking at a geographic and legal landscape that is literally shifting under our feet right now.
Right. So true. Welcome to this custom-tailored deep dive into the legal architecture of American corporate power. I mean, to get to the bottom of this migration, we're pulling from a highly detailed, hot-off-the-presses legal newsletter.
Yeah, it's from the Computer Law Group, authored by Jack Russo.
Right. And it's dated today, May 20th, 2026. So our mission for you today is to really figure out if this Dexit is just, billionaire bluster, or if it's a permanent restructuring of how the companies you actually invest in are governed.
And this CLG newsletter is just a goldmine for that, because it takes us past those sensational headlines and gets us into the actual mechanics.
Okay, let's unpack this, because to understand how corporate power is being redistributed, we really have to start with the spark, right?
Yeah, we have to look closely at that $55.8 billion wipeout, the now famous Tornetta decision.
Right, the Tesla pay package case.
Exactly. Chancellor Kathleen McCormick of the Delaware Court of Chancery opened her memorandum opinion with this just wildly provocative line. She literally wrote, "Was the richest person in the world overpaid?"
Oh, wow. I mean, that is an incredible way to open a judicial opinion.
It really sets the tone.
But how exactly did she justify completely unwinding a package that Tesla shareholders had, originally voted for and approved? Like, what was the legal weapon she used there?
Well, she applied this concept known as the entire fairness standard.
The entire fairness standard. Okay, what does that mean in plain English?
So in normal corporate law, a board of directors usually gets the benefit of the doubt. But when a controlling shareholder, which she deemed Musk to be in this case, is deeply involved in their own massive compensation deal, the legal burden completely shifts.
Oh, I see.
Under entire fairness, the board has to conclusively prove to the court that both the negotiation process and the final price were flawlessly fair to the minority shareholders.
So they are suddenly guilty until proven innocent, corporately speaking.
That is actually a really helpful way to think about it. And Chancellor McCormick found that the board's process was deeply flawed. She said the proxy disclosures to the shareholders were totally inadequate, and that Musk was a conflicted controller. Because they couldn't clear that incredibly high bar of entire fairness, she just ordered the complete rescission of the package.
And the dominoes started falling almost immediately after that. I mean, Neuralink reincorporated in Nevada by early February 2024.
Yep.
SpaceX moved its domicile to Texas by mid-February. And then, by June of 2024, Tesla shareholders officially voted to pull the crown jewel out of Delaware and convert the corporation to Texas.
If we connect this to the bigger picture, the perception among founder-led companies was that this wasn't just some standard legal disagreement.
Right. It felt personal.
It did. Musk's reaction transformed a single litigation outcome into this massive structural reincorporation movement. Founders felt like the rules of the Delaware game had secretly shifted underneath them.
Yeah, they felt it was becoming inherently hostile to visionary, deeply involved leaders. Think about it like picking the rules of a board game before you start playing, right? Delaware has been the classic rule book for 100 years. Everyone agrees to it.
Right, it's a standard.
But instead of just flipping the board in frustration because he lost a turn, Musk essentially decided to print an entirely new rule book in Texas, simply because he felt the classic rules had been rigged against him.
And the critique from legal scholars is exactly that. You shouldn't get to change the rules just because you lose a case.
Yeah, exactly.
But from the perspective of these highly influential executives, if the foundational rules no longer support the way modern tech companies are built and controlled, well, you have a fiduciary duty to go find a jurisdiction that does.
Which brings us to the actual mechanics of leaving. because sending an angry tweet and holding a shareholder vote is one thing.
Right, it's just talk.
Exactly. The courts actually allowing you to pack up and leave is another thing entirely. And we have to look at how the Delaware courts themselves just effectively blessed this exodus.
Yeah, the most pivotal moment for the actual mechanics of Dexit happened just last month on April 13th, 2026.
Okay, so this is super recent.
Very recent.
Yeah.
We saw a defining decision by Vice Chancellor Bonnie W. David in the consolidated Tesla derivative litigation.
Set the scene for us a bit. What were the plaintiffs trying to accomplish before that decision actually came down?
So right before Tesla's move to Texas was scheduled to officially take effect, several major institutional plaintiffs rushed to file lawsuits in Delaware.
Like who? Like big pension funds?
Yeah, exactly. The Employees Retirement System of Rhode Island and the Cleveland Bakers and Teamsters Pension Fund. They filed these suits in May and June of 2024, literally hours before the shareholder vote finalized the new Texas Forum Selection bylaw.
So they were trying to jam their foot in the door. They wanted to trap Tesla in the Delaware court system before the lock clicked shut.
That was the strategy, yeah. And Vice Chancellor David slammed the door anyway.
Wow.
She dismissed those Delaware suits and retroactively enforced Tesla's new Texas Forum Selection bylaw.
Wait, retroactively?
Yeah. In her opinion, she wrote that she was loath to second-guess Tesla stockholders' chosen forum. She respected the shareholder vote, effectively sending her own pending lawsuits out of her own jurisdiction.
Wait a second, how is that fair? Can a company really just change the rules of the game after a lawsuit has already been filed against them?
It seems crazy, right?
Yeah, I mean, if someone sues me, I can't just invent a new rule the next day saying, you actually have to sue me in Antarctica.
It sounds wild on its face, but it is deeply rooted in established Delaware precedent. You have to look back to a famous 2013 case called Boilermakers.
Boilermakers? Okay, what did that establish?
That case established that corporate bylaws are viewed as flexible, binding contracts between the company and its stockholders. So when you buy stock in a Delaware corporation, you aren't just agreeing to the rules as they exist today.
Okay.
You are legally, implicitly consenting to any future amendments of those bylaws, provided they are adopted legally by the board or the shareholders.
So buying the stock means you agree that the rule book is written in pencil, not pen.
Precisely. And Vice Chancellor David's ruling takes that logic to its absolute extreme. If bylaws are binding contracts, and the shareholders legally voted to amend the contract to say, all future litigation happens in Texas, then that is the new reality.
Even for cases filed right on the threshold.
Even those. Delaware effectively allowed its own chancery court to transmit its own pending cases right out the door.
Okay, so Delaware opened the exit door. Let's look at the destination now. Texas didn't just passively wait for these multi-billion-dollar companies to show up, did they?
Not at all. They purposefully built a massive legislative architecture to welcome them. The CLG newsletter details exactly how deliberate this whole thing was.
What did they actually build?
Well, first, Texas passed House Bill 19, which created a specialized business court that officially opened for business in September 2024.
So a dedicated court just for these corporate disputes.
Right. But more importantly, they passed Senate Bill 29, which formally codified the business judgment rule into Texas statutes.
Okay, explain the difference there for us. Because earlier we talked about that entire fairness standard that basically crushed Musk in Delaware. How does this business judgment rule compare to that?
It's night and day. The business judgment rule is a very strong written legal presumption that corporate directors and officers act in good faith and on the best interest of the company.
So they get the benefit of the doubt from the start.
Exactly. Unlike entire fairness, where the burden is on the board to prove they were perfect, the business judgment rule puts the burden entirely on the plaintiff.
Wow, okay.
To successfully sue a board in Texas now, a plaintiff has to explicitly prove fraud, intentional misconduct, or a knowing violation of law. It acts as this incredibly thick shield for executives.
And Texas went even further with Senate Bill 29 regarding derivative actions, right?
They did. They set a strict 3% minimum ownership threshold to even bring a derivative action at a publicly traded company.
Okay, let's break that down. A derivative action, which is essentially when a shareholder steps into the shoes of the company to sue the executives for mismanagement, requires a 3% ownership stake under this new Texas law.
Correct.
If you're talking about a $2 trillion company, 3% is tens of billions of dollars. I mean, that fundamentally eliminates the small nuisance lawsuits that constantly plague public companies in other states.
Completely eliminates them. What's fascinating here is that the entire Texas system is structurally engineered to be highly favorable to corporate defendants.
Yeah.
Even the appeals from this new business court go to a newly created specialized 15th Court of Appeals.
There is a massive catch here, isn't there? Basically, Texas just launched Corporate Justice version 1.0.
Right.
The code is written perfectly to protect founders. The interface is exactly what CEOs want, but it hasn't been stress tested by 1 million users yet, so nobody actually knows where the bugs are.
That is exactly the issue. The gap between the legislative architecture and the actual track record is staggering.
What do the numbers look like?
Well, the newsletter points out that the Texas Business Court saw 185 filings in its first year, but they were mostly localized in energy and real estate.
Okay.
As of this month, May 2026, there are 0 published fiduciary duty opinions in contested public company derivative actions.
0.
0. The precedent record is entirely blank.
So basically, Texas built a shiny, state-of-the-art corporate stadium. The architecture is gorgeous, but they haven't played a full season yet, so nobody knows how the new referees are actually going to call the game.
That's a perfect way to put it. Because Texas judges are schooled in common law reasoning, they are highly likely to look right back at Delaware case law as persuasive authority while they spend the next 3 to 5 years building their own precedents.
Oh, the irony.
Right. A company can physically leave Delaware, but for the near future, they are still going to be operating in its legal shadow.
Here's where it gets really interesting, though, because if you look at the headlines, Delaware is supposedly emptying out, right?
That's the narrative.
But I'm looking at the data in Jack Russo's newsletter, and they are actually gaining ground.
Yes, they are.
According to ISS corporate data, Delaware still retains 66.7% of the Fortune 500 by 2024. They captured over 81% of all U.S. IPOs.
Yep.
And they now hold 62% of the Russell 3000, which is, the broad index of 3,000 U.S. public companies. Their share actually rose 6 percentage points between 2020 and 2024. How is that mathematically possible when everyone is supposedly leaving?
Because the narrative of a mass exodus is only true for a very specific subset of companies. The reality is that Delaware saw the threat, and the empire struck back.
The empire struck back. I like that.
They launched a massive legislative counteroffensive to fix the exact pain points that were driving founders away, keeping the quiet majority of companies firmly within their borders.
Let's get into the weeds on how they actually stopped the bleeding. What did Delaware change?
The Delaware General Assembly passed 2 critical pieces of legislation. The first was Senate Bill 313, often referred to as the Moyles Fix.
The Moyles Fix.
Right.
Based on that huge court case.
Exactly. In the Moyles case, Delaware essentially ruled that boards of directors couldn't just sign away their core governance powers to powerful stockholders in private stockholder agreements.
And that must have terrified the venture capital world, right? Because those private agreements are exactly how founders and early investors maintain control even after giving up equity.
It caused absolute panic in Silicon Valley. So the Delaware legislature stepped in and passed SB 313, fundamentally rewriting the law to say, yes, you actually can use these private contracts to grant those special veto powers.
Wow, so they handed control back to the founders and boards legislatively.
They did. And then they followed it up with Senate Bill 21, which created true safe harbors for transactions involving interested directors or controllers.
Meaning, if a board follows a very specific checklist of rigorous procedural steps, Delaware will protect that deal from being easily attacked in court.
Precisely that. They also tightened the rules on how easily shareholders can demand to rifle through a company's internal books and records, which, was another major friction point for executives.
Makes sense. But what about the original $55.8 billion Spark, the Musk pay package? Did Delaware ever budge on that?
They did, actually.
Yeah.
Eventually, the Delaware Supreme Court partially reversed the Tornetta decision in late 2025.
Oh, really?
Yeah. They ruled that completely rescinding the pay package was an improper remedy. They reduced the damages to a nominal $1, and they slashed the plaintiff's attorney fees from an astronomical $345 million down to about $54.5 million.
But they didn't completely exonerate the Tesla board, did they?
No. They left Chancellor McCormick's core findings undisturbed regarding Musk being a controlling stockholder and the board's process being flawed. But by removing the massive financial sting And combining that with the new legislative fixes, Delaware restored a sense of predictability and contractual freedom.
If you are listening to this right now, think about your own risk tolerance. Imagine you are the CEO of a billion-dollar company deciding where to incorporate.
That's difficult.
Do you choose the strict but highly predictable parent Delaware, who just relaxed some of their strictest rules to keep you happy? Or do you choose the cool, protective new step-parent Texas, who promises you ultimate freedom but hasn't actually proven how they will react when a real crisis hits?
And the data shows the median company, the Standard Public Corporation, is absolutely choosing the predictable parent.
Yeah.
The Dexit migration is entirely concentrated among founder-led titans, heavily controlled companies, and highly vocal venture capitalists who value absolute control over legal predictability. For the vast majority of corporate America, predictability still wins out.
Which brings us to the ultimate stress test. We know the median companies are staying put and the billionaires are leaving. But what happens when one of those departing billionaires forces Wall Street to price that exit in real time?
That is the defining event pinpointed in the CLG newsletter. We are talking about the highly anticipated SpaceX IPO.
Right. On April 1st, 2026, SpaceX filed its confidential S-1 with the SEC. That's the foundational registration document required before going public.
Yep.
And the target valuation is just astronomical. They're looking at somewhere between $1.75 trillion and $2 trillion.
They're looking to raise $75 billion. But because SpaceX formally moved its incorporation to Texas in 2024, this IPO is going to force the entire global financial ecosystem to figure out exactly how to handle a Texas-governed mega-cap company.
Right.
This raises an important question. Will Wall Street accept a Texas Business Court forum provision and officer exculpation at a $2 trillion scale?
Because the friction of a move like this isn't just about filing new paperwork. The underwriter banks have to evaluate the risks.
Right.
The massive pension funds and institutional investors have to decide if they're comfortable with their shareholder rights being severely limited by that 3% derivative action threshold we talked about earlier.
And you have to consider the companies providing directors and officers insurance.
D&O insurance.
Right, the insurance that protects board members. They have to figure out how to price premiums for a Texas company when there is zero case law to base their actuarial models on.
Wow. Do you charge more because of the uncertainty, or do you charge less because Texas is so protective of executives?
Exactly. Even the major index providers, like the groups that manage the S&P 500, have to adapt their inclusion mechanics to handle a massive influx of Texas-governed public shares.
This isn't just an IPO. This is the maiden test flight of the entire Texas corporate system on Wall Street.
That's exactly what it is.
If the SpaceX rocket launches successfully and the market prices the Texas risk favorably without demanding a massive discount on the stock, it completely validates the Texas architecture. Every single hot startup drafting their IPO paperwork for 2027 is going to look at that and say, give me the exact same Texas blueprint.
But if the institutional investors push back, if the underwriters struggle to price the risk, or if those D&O insurance premiums skyrocket because of the legal void in the Texas Business Court, then the Dexit movement might hit a very solid brick wall.
Right.
Wall Street is going to be the ultimate judge of whether founder protection can actually coexist with global capital requirements.
So what does this all mean for you? Why should you care about the minutia of where tech billionaires file their legal paperwork?
It's a fair question.
Because understanding these corporate migrations gives you an incredible edge. It shows you exactly where capital, legal innovation, and corporate power are flowing. It tells you how the companies sitting inside your 401k are being governed, how accountable their leadership actually is, and what underlying risks those companies are exposed to.
The overarching takeaway from Russo's newsletter is that corporate law is no longer a static foundation. Laws are products, and states are fiercely competing to sell those products to the world's most powerful entities.
Yeah.
Elon Musk lit the match, and Texas eagerly built a state-of-the-art fireplace to contain it. But Delaware didn't burn down. They simply remodeled their house to keep the majority of their tenants happy.
The choice of a corporate home is no longer a one-size-fits-all default. It is a highly strategic, high-stakes decision based entirely on the delicate balance between founder control and legal predictability.
I want to leave you with one final, provocative concept that builds on all of this. Texas has marketed itself aggressively as the ultimate safe haven for executives.
Sure.
But they are still a court of law. What happens when a major Texas business court ruling inevitably goes against a powerful founder?
Oh, that's interesting.
Say 3 years from now, a Texas judge holds a high-profile CEO accountable. Will we see a third migration? A Texit.
The Texit.
Right. Will these founders simply pack up and move to an even more protective state like Nevada, which is already courting closely held entities? Are we witnessing the beginning of a permanent, never-ending race to the bottom in American corporate law where companies just hop from state to state the moment a judge tells them no?
We thought the legal foundation of American business was poured concrete. It turns out, if you have enough money and enough influence, you can just rip up the foundation and pour wet sand wherever you want, completely changing the shape of corporate America overnight. Thank you so much for joining us on this custom-tailored deep dive. Keep questioning the consensus, keep looking beneath the surface, and we will catch you next time.
Tune in next time on The Valley Current.